My name is Robert Pearce, and the short answer to your question is that you probably signed a contract with an arbitration provision. These days, virtually every customer agreement at a brokerage firm has an arbitration provision at the end of the contract. It's in bold, and it's binding, and it's final. And judges will enforce it. You will be required to go to an arbitration. When I started in the early 1980s, there were loopholes in ways that you could get around these FINRA arbitrations. Beginning in 1983, as the court docket started to get more and more crowded, the judges started to close the loopholes. And by 1988, the United States Supreme Court had closed all the loopholes and made arbitration final and binding on all investors and anybody that signed an arbitration contract for that matter. It's true, arbitrations are not, don't afford you all the rights that you might have in a trial. You don't have a jury trial. You don't have a trial by your peers. There is limited discovery in arbitration. For example, there are no depositions. It's true you have limited appellate rights. You can't appeal an arbitration. It's generally final and binding unless you can prove that there's some fraud or corruption, or the arbitrator didn't give you a postponement when you deserved it, or if the arbitrators exhibited evident partiality, or they refused to follow the law. The term is manifestly disregarded the law. But there are benefits to arbitration. For number one, it's you have experienced arbitrators that are knowledgeable of these issues that a jury might not understand and appreciate the nuances of. You can have a decision much quicker in arbitration than you can in trial courts these days. The expenses are less. With an attorney that is experienced in FINRA arbitrations, that's knowledgeable not only of the securities laws, but of FINRA rules and procedures and standards governing stockbrokers, and experience with the nuances of the arbitration process, you can be successful and recover all of your damages, if not a substantial amount of them. There are no limitations to the type of remedies that are available in arbitration. You can get rescission, you can get compensatory damages, you can get punitive damages, you can get attorney's fees, you can get interest. You can be made whole with the right attorney.